All right, we are on the record in file 23-21316-FH, People versus Cody Franklin Goebel. We are here today for a pretrial conference, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Muir.
B.B. Muir on behalf of the people.
Matthew Murphy, appearing on behalf of Mr. Goebel.
All right, and Mr. Murphy, where do we stand with Mr. Goebel's case today?
Your Honor, I was going to ask if we could set another pretrial on this matter. I have body cam footage I wanted Mr. Goebel to review. I haven't had a chance to have him in my office to do so. So I was hoping to get that done sometime in the next few weeks. And hopefully by the next pretrial, we can discuss the matter on the discovery, and then we can decide what we want to do at that point, Your Honor.
All right, Ms. Muir, anything we need to address from the people's side?
No, Your Honor, leave it in the discretion of the court.
All right, how about we adjourn to June 7th at 8:15?
Yes, Your Honor.
So June 7th at 8:15, Mr. Murphy, will you prepare a stipulation in order?
Yes, Your Honor.
And you can sign my name.
Thank you, Ms. Muir.
All right, Mr. Goebel, you'll need to log back in next time on June 7th at 8:15 a.m. You will use all of the same Zoom information that you used to log in today.
Okay.
All right, thank you. You can go ahead and log out.
You're welcome.
Thank you, Your Honor. Thank you, Mr. Goebel.
Thank you.
Mr. Daly, we have Mr. Matthews at the jail. Do you need a breakout session with him?
No, I don't, Your Honor.
Okay. We are on the record then in file 23-21254-FH, People versus Joshua David Matthews. We are here today for a pretrial hearing, and we are proceeding by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Muir.
B.B. Muir on behalf of the people, filling in for prosecutor of record Jackie Wise.
James Daly appearing on behalf of the defendant, Your Honor.
All right, and Mr. Daly, where do we stand with the case today?
Oh, we're ready to set it for trial, Your Honor.
Okay, how many days will you need for a trial?
I think we should be done in 2 days, but it's one of those that could very easily go into 3, Judge.
And
I would guess 2 days. I'm wrong as often
Okay.
as I'm right.
Ms. Muir, what are your thoughts on the amount of time that we need?
I would say 2 days at least, and the only thing Ms. Wise indicated was she's unavailable mostly for the months of June and September. I don't know when the court's looking to get it set, but she did say she was not available those 2 months.
So we need a 2-day trial date. Okay, we could do August 1st and 2nd.
Take a look.
That's fine for me.
Miss Wise is unavailable then.
Yes, I get that said in July somewhere. Yeah. We do August 22nd and 23rd, or 24th and 25th.
Is that July,
August.
August? Any of those dates are fine with me, Judge.
So I'm showing Miss Wise is off from the 22nd to the 27th as well. Or wait, maybe I'm in the wrong date, or sorry, the wrong month, I'm sorry. August. No, that should work. August 20, you said 22nd, 23rd?
Yes.
Yeah, that should work.
So August 22nd at 9 a.m., August 23rd at 10:30 a.m. Okay, thanks.
Your Honor, I'm going to want to schedule a bond hearing. I just got into this case. Unless I can do it now, otherwise I'll schedule a bond hearing.
I would rather it be scheduled with Miss Wise.
That makes more sense.
Judge, has the transcript in this case been ordered? Or do we have it?
We have a transcript.
Okay, perfect.
It was filed on April 20th.
Thank you.
Okay, so Mr. Daler, if you would like to contact the office and arrange a bond hearing, can go ahead and do that. Otherwise, we'll set the trial for August 22nd and 23rd. Anything else we need to address today?
I have nothing.
No, thank you.
All right. Thank you, Mr. Matthews. You can let the officer that's with you know that you are done with court for today.
Okay,
Joshua, I'll be over to see you today or tomorrow.
okay.
Thank you, Judge.
Thank you, Mr. Daly. All right, Mr. Murphy, you had Julia Betts on for today. Let's see, I've got one person here that I don't recognize in the Zoom waiting room, so let me see who that is. All right, the gentleman that just joined the meeting, are you able to hear me?
Yes, I can hear you.
Can you tell me your name, please?
Yes, Maurice Jones.
All right, Mr. Jones, your attorney, let's see, you just got logged in, so let me bring him in. Gave me that order on Mr. Jones. I said that on my desk and I forgot to bring it. Could you grab that one? Thank you. All right, we are on the record in People of the State of Michigan versus Maurice Leroy Jones, file 22-20751-FH. Also, People of the State of Michigan versus $2,169 in US currency, in which Mr. Jones is the respondent. That is file 21-216778-CF. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Muir.
And Phoebe Muir, on behalf of the people, for case ending in 20751.
David I. Goldstein, appearing on behalf of Mr. Jones in both matters, Your Honor. Mr. Jones, you need to turn on your camera and unmute.
All right, Mr. Goldstein, where do we stand with Mr. Jones's case today?
Your Honor, with regard to the forfeiture matter, I received a communication from the people yesterday. I think the matter is probably resolved. I could not find that communication again this morning, but I'm pretty sure I know what it said, and I think we've got that matter resolved. So I suspect that within the next few days, you'll be getting a consent order. As far as the criminal is concerned, Your Honor, I suspect that matter is going to go to trial.
And how long will you need for a trial?
In terms of days, Your Honor, 2?
Yes.
Your Honor, I don't believe we need to, I don't think this needs to be set for trial. I think this was going to get resolved with the forfeiture matter.
Okay. I was trying to look at, I thought that's what it said. I didn't want to say anything because I couldn't find it this morning.
Yeah.
Did you send it, Ms. Muir, or did?
No, Mr. Sneed did.
Right, and I did a search under his name and couldn't find it.
Check under Miss Brueggemann, maybe. She may have sent
Okay.
it.
Okay, I will.
So maybe just one more pretrial, and Your Honor, we can file the appropriate paperwork before that pretrial, and it may end up taking it off your docket.
That's certainly fine with me, Your Honor.
Y'all comfortable proceeding?
All right, can we get that done in 2 weeks on May 17th?
Easily, Your Honor, yes.
So May 17th at 8:15 a.m. We'll adjourn it to then.
Hey, Judge, we do have that active warrant on him for him not testing.
All right, Ms. Mayor, could I ask you to do a stipulation in order for that adjournment, please?
Yes, sorry.
All right, and so as Mr. Coates indicated, there is currently an active warrant for Mr. Jones related to his bond conditions. It does not appear that he's complied with his drug testing from March 24th. From March 24th, March 29th, April 7th, and April 10th.
That's correct, Judge. And he's also missed 3 more since that date. The last drug screen I have is dated March 20th.
Mr. Coast, just for my information, were his prior tests negative or positive?
They were positive for THC, but he does have a medical marijuana card. But
Okay, no other drugs?
correct.
All right, thank you. Judge, I would like to arraign him on the warrant. It would stand mute, ask the matter be set for a hearing on May 17th. We can address it at that time, Your Honor.
All right, so I'll enter not guilty pleas for Mr. Jones. On the contempt. And set a hearing for May 15th at 8:15 a.m.
May 17th, or Your Honor, you said May 15th, Your Honor.
I'm sorry, May 17th. I apologize.
Thank you.
Okay, so Mr. Jones, you need to log back in next time on May 17th at 8:15 a.m. You will use all the same Zoom information that you used to log in today.
Okay.
All right. Mr. Goldstein, Ms. Muir, is there anything else we need to address in this case today?
No, Your Honor, thank you.
No, thank you.
Okay. Thank you, Mr. Jones. You can go ahead and log out. Ms. Underwood, are you ready to proceed with Mr. Colwell?
It's not Mr. Colwell who's here in person, Your Honor, it's Mr. Cortez.
Mr. Cortez, I'm sorry.
Do we have a amended information in the file, Your Honor, with the count 2 attempt?
No, I do not see any amended information.
Okay, I'm gonna have to get on my Zoom now, Your Honor. I will contact the prosecutor's office.
Okay.
And see if we can get that. But we are gonna, I'd be entering a plea.
I'll go ahead and request that now. Rhonda, does he need to do a no contest or can he?
I believe he will do a no contest.
Okay, so
Or
I'll send
I-
along that as well. I know he's hard of hearing, Judge. So do you prefer if I come down in the courtroom for this one? I think that's why we.
Mr.
transferred.
Diaz is hard to be, Mr. Cortez?
I believe so.
Uh,
That was
Okay,
my,
he's here, yeah.
I think that's why we requested transport, because he's hard of hearing.
Okay. I wasn't,
It doesn't matter to me, Ms. Muir, whichever you want to try is, if you want to try doing it from there, that's fine.
Okay,
Uh,
I'll forward you the police report with that amended information. Give me 1 second.
Okay. All right, Mr. Murphy, back to Ms. Betts. Do you know where she is this morning?
I do not, Your Honor. I haven't been able to reach her. She does have active warrants already, I believe, for a new charge and that an already currently pending district court matter that she failed to appear for.
We are on the record in People versus Julia Rayanne Betts, file 22-21100-FH and 23-21264-FH. Today is the date set for a pretrial conference in both of these matters. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record.
EB Mir on behalf of the people.
Matthew Murphy appearing on behalf of Julia Betts.
And Mr. Murphy, well, the record should reflect that this matter was set for hearing at 8:15 this morning. It is now 8:53. Ms. Betts is not logged into the Zoom session and she is not present here in the courtroom. The Zoom session has been running since shortly before 8 a.m. I've identified everyone in that Zoom waiting room, and Ms. Betts has not been there at any time. Mr. Murphy, is there anything you would like to state for the record at this point?
Your Honor, unfortunately, I don't know where Ms. Betts is. She missed a court date earlier, I believe this week or later last week. Down in district court, and she had a pending case already. She had a warrant for. We've tried to reach her. My office tried to reach her in regards to those matters, as well as to see if she was aware of today's date. But we have not been able to reach her. So unfortunately, that's the most information I can give the court at this time.
All right, I would note in 23-21264-FH does already have a bench warrant for violation of bond conditions. In that case, she has failed to appear here this morning, so I am going to revoke and forfeit any bond she might have in either case, issue bench warrants in both cases for the failure to appear here this morning. And I will set bond on the bench warrant in the amount of $50,000 in each case.
Yes, Your Honor. Thank you.
And I'll also just add for the record that she has one new felony warrant and one new misdemeanor warrant for new charges that have been issued against her.
Okay,
Thank you, Your Honor. That was all that I had scheduled this morning in your court. I was gonna go ahead and log off. Have a good morning.
great. Thank you, Mr. Murphy. Okay, Ms. Underwood, Mr. Rutledge is here by Zoom. Are you ready to proceed with him?
No, I would need to speak with him in a breakout, Your Honor.
Do you want to log your device in so we can do that?
Okay. And I double checked with Mr. Cortez, and I think there was a mix up. He doesn't have a hearing difficulty.
Okay. I believe.
I
the
didn't
file-
have any notation in my file, and I know I have one that does.
Looking
but
at the
it's
file,
not
looks
Mr.
like we
Cortez.
brought him here so he could be fingerprinted.
I'm sorry?
I believe we requested him to be in person so he could be fingerprinted.
Okay, I'm probably getting my people mixed up. That's, yeah.
Problem. Ms. Muir, when they have that amended information ready, could you have them email that directly to me? I don't have Kelly in the courtroom with me today.
Yep, I can do that.
Thank you.
I'll just go back, Your Honor.
Okay.
Talk to Mr. Rutledge.
Okay. All right, Mr. Rutledge, if you give me just a moment, I'm going to put you in a breakout session with Ms. Underwood.
Okay.
All right, we are on the record in People versus Lucas Allen Rutledge, file 23-21240-FH and 23-21241-FH. We are here today for pretrial conferences in both of those files. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Muir.
E.B. Mayor on behalf of the people.
Ron Dunwood on behalf of Mr. Rutledge this morning, Your Honor.
Ms. Underwood, where do we stand with Mr. Rutledge's case today?
I believe, Your Honor, another pretrial would be helpful. I'm in contact with Mr. Rutledge's parents. Mr. Rutledge is Zoomed today from Sacred Heart in Richmond, Your Honor, which is, I think, an appropriate place for him to be. I would ask for another pretrial the first part of June in this matter in hopes that we can resolve things.
All right, so the case at this point is 96 days old, and we seem to run into issues with Mr. Rutledge being in rehab, leaving rehab, going back to rehab. At this point, I think it just needs to be set for trial, and we need to deal with these issues. I'm not, at this point, given the way this case has proceeded, willing to allow any further adjournment. So how long will you need for a trial?
Probably a day.
Would we try them both together or would they be two separate? It would be 2 days if they're going to be separate.
Thank you.
So it looks like there's separate incident dates. Ms. Underwood, I guess I would defer to you if you wanted to try them together. I would
No.
do that.
No.
Yeah, okay, so we'll try them separately. The 21240 case is the lower case number. That is the domestic violence and R&O case. So I'm sorry, Ms. Muir, did you say 2 days for that?
Just 1 day for that then. I just meant 2 days for,
I
one
see.
for each trial. Yeah.
Okay. All right, so we'll set this for a 1-day trial.
You want to do it as a backup to Tyler Clark on June 7th?
Give me 1 second. I'm trying to get a hold of Kelly to see what dates are going to work.
Okay.
So we need a 1 day for Lucas Rutledge. No, let's not do that. July 25th at 9 a.m.
That works for the people.
Thank you, Your Honor.
Thank you. That was Tuesday, July 25th. Let's do a final pretrial. Wednesday, July 12th. All right, and so apparently Mr. Rutledge has had an issue reporting to Mr. Coast as directed. Mr. Coast, have you have a letter in the file? Have you requested a bench warrant?
Yeah, I did request a bench warrant, Judge. He mentioned that he was going to check himself back into treatment. He was ordered to do twice weekly drug testing, did not do that. He did mention he was thinking about checking back into treatment. I told him to get me verification if he did in fact did that, and I do not have that verification. So if he is at Sacred Heart, I have no idea what date he turned himself into that treatment facility.
I can have somebody send it over.
Yeah, Lucas, if you're there, you need to sign a release of information, and so I could get that information.
Okay.
Like I requested before.
Okay.
And so, Mr. Rutledge, this is about the third or fourth time that we've been through this kind of a thing with you. You are required to report to Mr. Coast as directed. And if he tells you, if you decide to check yourself in and he tells you to provide him that information, you need to do it that day, not the next time that we show up and have a hearing.
Okay.
You know, I don't know what to do at this point other than to issue the bench warrant and, you know, just hold you at the jail, because we don't seem to be able to keep track of you because you just seem to be doing what you want and telling us about it later.
Your Honor, I would ask the court to consider not entering the bench warrant at this time and give Mr. Rutledge the rest of the day to provide that proof to Mr. Coast.
Has the bench warrant already been issued, Mr. Coast?
It has, Judge. It appears it was signed on April 28th.
Well, at this point, I would say Mr. Rutledge is again been through this and had an opportunity to avoid that bench warrant being issued by contacting Mr. Coast as he was directed, and he didn't do that. So I'm going to leave that in place.
Yeah, I called and I left him a message. When I went to jail the last time, my girlfriend thought I was using, and she wouldn't allow me to stay there.
Mr. Rutledge,
So I felt safer coming
I don't-
here. So I didn't want to be out there.
Well, again, Mr. Rutledge, your job was to provide verification to Mr. Coast as he directed you to do, and you didn't do that. So that's where we are. I've made my decision, Mr. Rutledge. You can go ahead and log out.
Thank you, Judge.
Ms.
Um,
Underwood, we have I'm sorry.
I was gonna say, Rhonda, just get a hold of me before the next pretrial. I haven't really heard from you on this case.
All right, Ms. Underwood, we have Anthony Moore here. Do you need a breakout session with him?
I don't believe I do, Your Honor. Thank you.
All right, Mr. Moore, are you there? You need to unmute your device and turn on your camera, please. Thank you. We are on the record in People of State of Michigan versus Anthony Harris Moore, file 20-19796-FH and 20-19849-FH. These are both set for hearings on probation violations. We are proceeding today by video conference. Can I first have Ms. Underwood place your appearance on the record?
Rhonda Underwood for Mr. Moore, Your Honor.
Ms. Underwood, where do we stand with respect to Mr. Moore's cases
I've
today?
spoken to Mr. Moore and I've spoken to Ms. Holly on this matter, Your Honor. The count as to the assault provision will be dismissed, not charged. Mr. Moore's district court case was nolle prost. So Ms. Holly has agreed to dismiss that, Your Honor, and only go forward on the failure to report charge, Your Honor, and Mr. Moore will plead guilty to that.
All right, Mr. Moore, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Anthony Harris Moore?
Yes, Your Honor.
Mr. Moore, do you understand that you have a right to contest this violation of probation charge and to have a trial on it?
Yes, Your Honor.
Do you understand that throughout the trial, you'd be presumed innocent until your guilt is proven by a preponderance of the evidence?
Yes, Your Honor.
You have a right to have all of the witnesses against you appear at the trial. You or your lawyer could ask the witnesses questions, and you also have the right to have me order any witnesses that you have for your defense to appear at your trial. Do you understand that?
Yes, Your Honor.
You are not required to testify at the trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes, Your Honor.
On the other hand, you'd also have the right to testify at the trial if you wanted to testify. Do you understand that as well?
Yes, Your Honor.
How do you plead then to the charge that you violated the terms of your probation by failing to report?
Guilty.
So you had originally pled guilty in this case back in March of 2020, is that correct?
Yes, Your Honor.
And sometime thereafter, you were placed on probation. Sorry, if you answered, I didn't hear you.
Oh, I'm sorry.
You were placed on probation in May of 2020, is that right?
Yes, Your Honor. Sorry.
And there's an order of probation in the file that appears to have your signature on it. Did you receive and sign your order of probation?
Yes, Your Honor.
And one of your requirements in that order of probation was that you report as instructed to your probation officer. Is that correct?
Yes, Your Honor.
And did you fail to report on November 29th, 2022?
Yes, Your Honor.
And did you not report it at any time between November 29, 2022 and when you got picked up on the warrant?
Yes, Your Honor. I did not report for that in between the time.
Okay, sorry, your audio didn't come through quite clearly. Could you say that again?
I said I did not report in between that time.
Okay. I'll accept the plea then. It has been given understandably, voluntarily, and accurately. Mr. Moore has had full knowledge of his rights. He's had competent counsel. I will refer this matter to the probation department for an update of your pre-sentence investigation.
Your Honor,
Yes,
may we, you're in Dawn Farms, correct, Mr. Moore?
Yes, sir.
Can we put the sentencing out to make sure he completes Dawn Farms?
that's fine with me. How far out do we need to go to do that?
When's your out date, Mr. Moore?
My out date is Friday at 10:30 a.m. But they're putting me in residential program just because I want to keep into the process of going to meetings and stay in with the probation.
How
or
about
with the-
just,
with the rehab.
okay, then how about 2 weeks, Your Honor?
All right, so that would be,
Your Honor, I'm not here the week of the 15th.
We could put it 3 weeks.
No, with me being on probation and going to transitional, because it's not like rehab, it's not
I
Spera.
understand.
Is that okay?
I understand.
all right, let's go then with June 25th at 8:15.
Thank you.
What was that date, Your Honor?
June 25th
Oh, thank you.
at 8:15. All right, anything else we need to address with this case?
No, Your Honor, thank you.
All right, Mr. Moore, you can go ahead and log out.
Okay. How do I do this? Oh, there it is.
This is Judge Olsaver again. Could we have Julia Reeves in the Zoom room for us? Thank you very much. can have him bring Mr. Cortez into the courtroom.
Is he up?
He's in lockup.
Okay. Just on this one, sorry.
What's that?
Is he on this one?
Yeah. Right.
Morning, Your Honor.
Good morning. Just 1 second. Okay, Ms. Underwood, we do have Mr. Cortez in the courtroom now,
Great.
and we do
I'll
have
be
the
right
amendment.
up, Your Honor. I had to go find battery. Thank
Okay.
you.
All right, we are on the record now in file 22-21135-FH, People versus Juan Manuel Cortez. We are here today for a pretrial conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. Muir.
PB Mayor, on behalf of the people.
Rhonda Underwood on behalf of Mr. Cortez, Your Honor.
All right, Ms. Underwood, where do we stand with Mr. Cortez's case today?
Thank you, Your Honor. Mr. Cortez, through a plea bargain negotiated with the prosecutor and through a Cobb's conference held with the judge, will be pleading guilty to count 2 of an amended information, possession of contraband, specifically Suboxone, Your Honor, by a prisoner, a 2.5-year felony, with the habituals on this case being dismissed, Your Honor, and with the Cobb's agreement to the low end of the guidelines, Your Honor.
All right, Ms. Muir, is that a complete and accurate statement of the plea agreement?
It is.
All right. Mr. Cortez, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
You are Juan Manuel Cortez.
Yes, I am.
Mr. Cortez, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today? I'm sorry, plead no contests today to count 2 attempted prisoner possession of contraband?
Yes, it is, Your Honor.
Are you satisfied with Ms. Underwood and the advice that she's given you?
Yes, I am, Your Honor.
You understand that the maximum penalty for this offense is up to 2.5 years in prison and or a $500 fine?
No, Your Honor, I thought it was 17 months. Must have got confused or something.
The maximum is 2.5 years allowed by statute.
Yeah, but I definitely got confused. I thought it was 17 months, Your Honor.
Okay, so what I'm telling you, Mr. Cortez, is that the maximum possible penalty by statute is up to 2.5 years in prison.
We aren't talking about the maximum guideline range. We're talking about the maximum by the statute.
That's a possible, what you're saying is a possibility.
Your attorney has stated an agreement that we have with respect to what your sentence will be. But I'm required by law to tell you what the maximum statutory penalty is.
So it's still the low ends, but you're letting me know because of the law that I need to know.
Correct.
All right, well, yes, I understand. Thank you both.
Okay. Neither, other than as we've discussed on the record here this morning, neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Muir?
That's correct.
Ms. Underwood?
That's correct, Your Honor.
Is that also your understanding, Mr. Cortez?
I believe so, yes, Your Honor.
If a guilty or if a no contest plea is accepted, there'll be no trial. That means you're giving up the rights that you would have at trial. I'm going to explain those rights to you right now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify if you wanted to testify. Do you understand, Mr. Cortez, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
No, I did not, but I do now.
Okay. Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
I don't really understand what that means.
Okay, so application for leave to appeal means that the appellate court would look at your application and determine whether or not they thought they should hear it, or and they could decide either way. An appeal by right means you have an absolute right to file that appeal and have it heard by the Court of Appeals. So by pleading today, you may be giving up the right to have it done by right and rather only have an appeal done if an appellate court decided they should hear it.
Thank you for explaining that. I understand.
Okay. If you are not a citizen of the United States of America, a conviction of a crime can result in deportation exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've discussed with you here today?
Explain, great, thank you.
Do you understand you're giving those rights up?
For this COPS agreement, yes.
Okay. How do you wish to plead to the charge that on or about May 22nd, 2022 in Adrian Township, Lenawee County, Michigan, that you did commit the offense of attempted prisoner possession of contraband?
So I say no contest?
Yes.
No contest, Your Honor.
Has anyone made any threats or promises to induce you to plead no contest to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you'll be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court this morning, or that it was not your own choice to enter that plea?
Yes, I do, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Cortez to plead guilty? Or, I'm sorry, no contest.
No, Your Honor, but I do think we need to place a basis for the no contest on the record. I had only mentioned the no contest because I was getting it mixed up with another individual. But if he wants to plead no contest, I have no objection, but we do have to place a basis for that.
All right. So Ms. Underwood, what is the basis for Mr. Cortez's no contest?
Mr. Cortez.
If that please the course and we're still sticking with the same COPS agreement, that's fine.
Yeah, because you remember what happened, right?
As far as doesn't matter, it went on between you and that. You want to try. That's fine.
Your Honor, we can just do a guilty plea. It'd probably be more appropriate.
Okay. Mr. Cortez, do you understand that all the rights that that I have already described to you, you would have, and everything is the same with respect to a guilty plea as it would be with the no contest plea that you've already stated?
Okay.
Okay, so let me ask you that again, then how do you wish to plead to the charge that on or about May 22nd in Adrian Township, Lenawee County, Michigan, that you did commit the offense of attempted prisoner possession of contraband?
Guilty, Your Honor.
All right. Again, has anyone made any threats or promises to induce you to plead guilty?
No, Your Honor.
Do you understand that if I accept that plea, again, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record here this morning?
Yes, Your Honor.
Or that it was not your own choice to enter that plea?
Yes, Your Honor.
Other than the agreement that we discussed here this morning, has your attorney promised you any other particular sentence or estimated what your sentence would be?
But just about what you guys said about the low ends and high guns, that's estimation. That's
Okay, so you understand that your sentence is controlled by the agreement that we placed on the record here today?
Yes, Your Honor.
And that if anyone else has said anything else to you about the sentence, I'm going to follow the agreement and not whatever anyone else might have told you.
Okay, yes, Your Honor.
Okay. Is it your own choice to plead guilty today?
Yes, Your Honor.
Ms. Underwood, do you want to review the factual basis?
Mr. Cortez, I take you back to 6/22/22. Were you an inmate at the Gus Harrison facility here in the county of Madison, in the township of Madison, county of Lenawee, state of Michigan?
So incarcerated since 2019, yes, Your Honor. Yes,
And you were an inmate there, correct?
yes, I was in there.
And at that time, did you have in your possession Suboxone?
That's what the results came back. I didn't know what it was.
You had Suboxone in your,
But if the test
And-
result, yes.
and you knew you had no prescription for Suboxone or any lawful right to have it.
Yes.
All right, Ms. Muir, are the people satisfied with the factual basis?
Yes, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Ms. Muir?
It has.
It has, Your Honor.
All right, I will accept the plea then. It's been given understandably, voluntarily, accurately. Mr. Cortez has had full knowledge of his rights. He's had competent counsel. I will refer this matter to the probation department for a pre-sentence investigation, and we will set sentencing for June 15th at 8:15 a.m.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
I believe the reason that we had Mr. Cortez here in person today was because we needed his fingerprints taken. So they'll take him across the street to the jail and they will do the fingerprints over there. Thank you.
Thank you, Judge.
Thank
Is this, well, next time we're going for papers for the pre-sentence with the certificate.
you bring one.
The certificate from the doctor, the place.
Okay, you can provide all that to the probation officer who talks to you.
Okay.
Okay?
All right. Enjoy that.
Thank you.
This one? Do I follow them? Yeah. Enjoy that, Your Honor.
Thank you, sir. You too.
Your Honor, did we take Demetric Lofton off the docket? I noticed Mr. Goldstein wasn't here anymore.
He actually just logged back in.
Oh, okay.
I received a note yesterday that he, that was going to be nolly pros.
Okay, it's Isaac's case, so I wasn't sure. Isaac didn't really tell me anything about it.
Your Honor, I'll be going back to my Zoom.
Okay. We have Ms. Reeves here, so once you get down there,
Thank
are you
you.
going to need a breakout session with her?
Just briefly, Your Honor.
Okay. Ms. Reeves, as soon as Ms. gets back to her device, I'm going to put you in a breakout session so you can speak to her. That device, Ms. Reeves, at the jail is muted at the moment. I'm going to send a request to unmute that. All right, I'm going to put you in a breakout session now so you can speak to her as soon as she gets in front of her computer.
All right, thank you, Your Honor.
Okay, Mr. Goldstein, were you logging back in for Demetric Lofton?
Yes, Your Honor.
Okay,
I do
My-
see. Oh,
my understanding was that that was going to be nolly pros.
Right, and I just wasn't sure whether that had been filed or not. I didn't want to let the court, leave the court hanging.
Okay, I
I
Sure.
see a note from Mr. Sneed that he'll have it filed today, so I don't think it is yet, and but I don't think there's
Okay.
anything placed in the record.
all right. I don't see any need to conduct a pretrial then unless someone else does.
No, Your Honor. As I said, I just didn't want to log off and leave the court hanging, so thank you.
Okay, thank you. All right, for the gentleman that is brought into the meeting, can you tell me your name, please?
Gwen?
Sorry, the audio did not pick you up clearly. Did you say Brandon Gwynn?
Yes, sir.
Okay. Okay, Mr. Gwynn, your attorney is working with another client right now. I'm going to put you back in the waiting room for a few minutes and we'll get to your case next.
All right, thank you.
All right, we are on the record in file 23-50336-PP, Norma Brunt versus Julia Reeves. That is set for a hearing on alleged violation of a personal protection order. Also files 22-20698-FH and 22-20976-FH and 22-20985-FH. Those are all set for hearings on alleged probation violations. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Mayer.
Be mayor on behalf of the people.
Rhonda Underwood on behalf of Ms. Reeves this morning.
Okay, and Ms. Underwood, where do we stand with Ms. Reeves' cases today?
It's my understanding Ms. Reeves has a preliminary examination scheduled downstairs on the 30th, Your Honor, and we would ask that this matter be adjourned till after that. These matters.
So you said on May 30th?
That's correct.
Ms. Mayer, is there anything we need to address from the people's standpoint?
No, I'll leave it in the discretion of the court.
Okay, so I will adjourn it then till June 7th at 8:15 a.m., which is, I believe, the date that if she's bound over on something at the prelim, that she would be up here for arraignment.
Thank you, Your Honor.
Anything else we need to address today, Ms. Underwood?
No, Your Honor. Thank you.
Does Ms. Brunt need to log in next time, or is she okay to wait until if or when this is set for a hearing?
It would be fine with me if she wants to wait until we know we're going to set this for a hearing. The next date is just a Wednesday morning, so I wouldn't intend to be having the actual hearing at that date. So we can just notify her if this gets set for an evidentiary hearing, when that date will be. So Ms. Brunt, if you don't want to log in, you don't have to. You're obviously welcome to if you want.
Okay, and this will be June 7th, correct?
June 7th, yes, at 8:15 a.m. and all of our Zoom information is the same.
Okay, thank you, Your Honor.
Okay, thank you.
Okay. Thank you.
Ms. Underwood, could I ask you to do the stipulation in order for those adjournments?
Thank you.
And we have Mr. Gwynn. Do you need a breakout session with Mr. Gwynn?
I've spoken to the probation department. I just need a very brief breakout with Mr. Gwynn, Your Honor. I think I know exactly what we're doing here.
Okay, 1 second. Okay, we are on the record in People versus Brandon Lee Gwynn, file 21-20362 FH, 21-20363 FH, 21-20364 FH, 21-20365 FH, and 21-20367 FH. All of these are set this morning for arraignment on probation violations. We are proceeding today by video conference. First, let me ask Ms. Underwood to place your appearance on the record.
Ron Underwood for Mr. Gwynn this morning, Your Honor.
All right. And Ms. Underwood, do you know how Mr. Gwynn would like to proceed today?
Absolutely, Your Honor. Mr. Gwynn wishes to enter a plea to the violation in this case. Your Honor, Mr. Gwynn is currently serving time in the Michigan Department of Corrections pursuant to the case that is mentioned in the violation.
Okay. Mr. Gwynn, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
You are Brandon Lee Gwynn?
Yes.
Mr. Gwynn, have you had an opportunity to review the warrant for probation violation?
Yeah.
And have you had an opportunity to discuss it with Ms. Underwood?
Yes, I have.
The warrants allege that you violated the terms of your probation on December 17, 2021 by stealing catalytic converters from vehicles and pleading guilty to that offense to two counts of larceny from a motor vehicle in Hillsdale County Circuit Court on January 24th, 2022. In these cases, in file number 21-20362-FH, you had previously pled guilty to larceny in a building, and the maximum penalty for that offense is up to 4 years in prison. In file 21-20363-FH, you had previously pled guilty again to another count of larceny in a building. Maximum penalty for that offense is up to 4 years in prison. In file 21-20364-FH, you had pled guilty to another count of larceny in a building. The maximum penalty is again 4 years in prison. In file 21-20365-FH, you had pled guilty in that file to another count of larceny in a building with maximum penalty 4 years in prison. And in file 21-20367-FH, you had again pled guilty to a count of larceny in a building with a maximum penalty of 4 years in prison. Are you satisfied with Ms. Underwood and the advice that she's given you?
Yeah.
Do you understand that you have a right to contest these violation of probation charges and have trials on them?
Yes.
Do you understand that throughout that trial, your guilt would be, you would be presumed innocent until your guilt is proven by a preponderance of the evidence?
Yes.
You have a right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions, and you also have the right to have me order any witnesses that you have for your defense to appear at your trial. Do you understand all of that?
Yes, sir.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes, Your Honor.
On the other hand, you'd also have the right to testify at your trial if you wanted to testify. Do you understand that?
Yes, Your Honor.
How do you plead to these charges that you violated the terms of your probation by stealing catalytic converters?
Guilty.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yes, Your Honor.
Has anything been promised to you in order to get you to plead guilty?
No, Your Honor.
Has anyone threatened you in any way in order to get you to plead guilty?
No, Your Honor.
If I accept the plea, you will be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record here this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
So you were in each of these files, after pleading guilty, you were sentenced and placed on probation. Is that right?
Yes, Your Honor.
And did you receive and sign orders of probation?
Yes.
And so you were aware that one of the terms of your probation was that you not engage in any further criminal activity. Is that right?
Correct.
And on January 24 of 2022, did you plead guilty to 2 counts of larceny from a motor vehicle in Hillsdale County Circuit Court?
Yes, Your Honor.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Gwynn has had full knowledge of his rights and he's had competent counsel. I will refer this matter to the probation department for an update of your pre-sentence investigation and set sentencing for let's go with June 15th at 8:15 a.m.
What date, Your Honor?
June 15th at 8:15 a.m.
Thank you, Your Honor.
Okay, if there's nothing else we need to address in these cases today, Mr. Gwynn, you can let the officer that's with you know that you are done with court for today.
All right, thank you.
Thank you.
Your Honor,
Yes.
do we have Mr. Colwell from the MDOC?
I do not have Mr. Colwell logged in.
You're free to go, Mr. Gwynn.
All right, thank you.
Yeah, I don't have Mr. Colwell logged in, and I don't see in the file a writ for him. So I don't think we can do anything with his case today other than adjourn him and make sure that a writ gets done next time. Ms. Meir, if you're there, if we adjourn this to May 17th, is that enough time for your office to prepare the writ?
Yeah, I would think so, Your Honor.
Could we
Okay.
do it 1 week later, Your Honor?
Oh, that's right. I'm sorry, I'm not here that week. So the following week would be. Okay, so let's go with May 24th. All right, I believe that is everything unless I missed something.
Thank you.
The only other thing I have is Kyle Bryan.
Kyle Bryan, I've got a note on my docket that was adjourned to May 24th.
Okay.
All right, thank you very much. Have a nice day.
Yeah, have a good day.
Yeah.
You too.